Good evening. I'd like to just take a few moments before we start with our official broadcast to welcome you all. Is this working okay? Everybody can hear? Wonderful. My name's Nancy Leifer. I'm co-president of the Missoula League of Women Voters, and I welcome you all here this evening. The League is a nonpartisan organization that has a long tradition of hosting educational and candidate forums. This evening we're going to be talking about our civil liberties and what's been happening with them lately in the way that we've been dealing with them under the war on terror. Another tradition that we have is we always have questions from the audience be written down. We do that for several different reasons. One of them is so that we can read them into the microphone and they'll be very loud and go and be able to make it into the recording easily. And another is so that we can be sure that we aren't repetitive and that things are moving along. So I know all of you undoubtedly have pens and note cards already because we have two wonderful people who've been making sure everyone has those. If anyone doesn't, raise your hand and they'll come and make sure. There's a person right down here in the front row who needs some. Okay. Please remember to turn off your cell phones. Anyone who has cell phones, let's do that now so we don't have to worry about it later. In terms of logistics, if you go back out the theater, the bathrooms and the water fountain are just to the left as you hit the main hallway out there. And we'd like you to thank you again for coming this evening and encourage you to be an attentive and respectful audience as we hear from our panel and hear questions from the audience as well. So thank you very much, and in just a few minutes we'll start formally. We are going to be taping on MCAT tonight, and so this will be available in about a month for viewing both off their website, and also they also will be having DVDs available, I think, if need be also. Thank you very much, and I'll turn it over to Teresa.
Good evening. In these perilous times, are the citizens of this nation informed enough, determined enough, and confident enough to insist that we can achieve security as a nation without compromising our constitutional liberties? Those who know intimately of the historic compromises to citizen liberty, compromises of citizens' liberties in the past, as in the film that we just watched, resulting in the loss of their freedom, have vowed never again. So when do we take stock as citizens to consider whether, outside of our full awareness, we face abridgments of our rights? Think back to the year 2000. Are we as free today as we were then to speak freely, to dissent, to advocate for change, to be secure in our persons, homes, and communications, and know that each of us would be afforded due process, will be afforded due process, should the lawfulness of our individual actions ever be questioned? The title of our forum tonight is Trading Liberties for Security in Times of War. We thank you for being here tonight. My name is Teresa Jacobs, and I'm a proud member of the League of Women Voters of Missoula. For almost a century, the National League has been actively vigilant in protecting our individual liberties guaranteed by the Constitution of the United States. The League's co-sponsors this evening here on the beautiful campus of the University of Montana are two student groups. The UM Students for Peace and Justice, represented here by Kathleen Todd, and the MSW Social Action Network group, represented by Zach Reimers. We're happy that our forum is being videotaped by MCAT tonight as part of a media assistant grant program to nonprofit organizations. It will be available in about a month online. Before introducing our guests, I just want to remind everybody to make sure their cell phones are turned off. We will be relying on questions from the audience tonight. That's kind of a tradition of the League here. It helps us to make sure that all the questions are, everybody can hear the questions, and also that the most popular topics will be covered. There's a committee of League people who are going to be reviewing those. So if you don't have If you don't have a card, there's 2 volunteers that can help you. So in about an hour and a half from now, after our speakers are finished, we'll have about a 3-minute break where you can turn in those questions. So without further ado, I am going to introduce our guests. First, we have Clem Work. Clem taught reporting, editing, media law, ethics, and magazine production at the University of Montana School of Journalism for 23 years, from 1990 to 2013. Before that, he had a 23-year career in newspapers and news magazines, including a senior editor position at U.S. News and World Report. He was associate director of the Reporters Committee for Freedom of the Press in Washington, D.C. from 1980 through 1982. Clem received a bachelor's from Stanford University in political science and international relations in 1966, and a law degree, a JD, law degree from Golden State University in 1975. His book, which I meant to bring a copy, called Darkest Before Dawn, Sedition and Free Speech in the American West, was published in 2005 by University of New Mexico Press. That book led to a gubernatorial pardon of 78 World War I sedition convicts. That happened in 2006. The book also led to the 2008 documentary that we just watched, that some of us just watched, Jailed for Their Words. Clem has traveled overseas and hosted clinics at as part of journalistic outreach to set up exchanges, internships, and collaborations. He has lectured about free speech in the U.S., Bhutan, Nepal, India, Japan, Myanmar, and Syria. And so, Clem, would you like to speak from where you are or come up to the podium?
I'd rather come up
Okay,
to the
good.
podium.
So I think I'm going to introduce one speaker at a time because it's such a mouthful.
Thanks very much, Teresa. Can everybody hear me all right? All right. For those of you who did watch the film, I just want to plug the website that I developed for that project. It's called seditionproject.net. If you want to go there, there's many layers to it. There's a lot of depth, and you can learn a lot more about the individual prisoners and about the context and so forth. And while I'm in the business of plugging things, the Montana Historical Society has just put up a new page or pages called Montana and the Great War. Just lots of different stories about World War I and Montana's involvement in the war in many different ways, both for civilians as well as for soldiers. And the best way to get to that, I'm not going to do the complicated URL, but just go to the website for the Montana Historical Society and go to the education tab, and you'll find that, or they may even feature it on the front page. So these, for those of us who have been involved in some way in World War I and writing about the events of World War I, these days are particularly significant. 100 years ago this Thursday, on April 6, 1917, the U.S. Congress declared war on Germany to, in the words of President Wilson, make the world safe for democracy. And as we all know, Montana newly elected representative Jeanette Rankin, who had just been sworn in 2 days earlier, or actually on April 2nd, cast one of the 50 dissenting votes against the declaration of war, which was not as famous as her lone dissenting vote against World War II on December 8th, 1941. Well, not only did Congress's declaration of war seal the fate of nearly 1/3 Americans who were killed or wounded in the Great War, which included 1,000 Montana soldiers who were sucked into what the protagonist in All Quiet on the Western Front called the mysterious whirlpool. but it also set off a chain of events that had a deep impact on our constitutional rights of free speech. And it continued that cyclical pattern that has been referred to already, this endless struggle between liberty and security. In fact, the title of my book, Darkest Before Dawn, kind of reflects that cycle. Maybe I should have called it Darkest Before Dawn, Before Dark. But to be more specific, sedition prosecutions, both state and federal, the federal law was through the Espionage Act, triggered a judicial review that for the first time reached the US Supreme Court and triggered the first real examination of the First Amendment in our nation's history. Well, first let me just define sedition a little more closely. Here's one definition: the illegal promotion of resistance or insurrection against the government, usually in speech or writing. So sedition is an ancient notion that really protects majesty and unquestioned authority. It's a quintessentially political crime, and its purpose is to protect the special veneration due to those who rule. Well, the crime of sedition is alive and well and actively prosecuted in many other countries. But I'm going to hope to show you how and why the law of sedition no longer prevails in this country. But even in the early days of the United States, the supreme and unquestionable authority of the governor and the government were being challenged by natural law, natural rights, the doctrine of John Locke and others, which informed both the American and the French Revolution. We all know the beginning words of the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, and so on, with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, and this is where I have it in boldface, so I want to emphasize this, governments are instituted among men, deriving their just powers from the consent of the governed. So that was an anti-authoritarian kind of notion and statement that informed the founders of this country. Madison put it another way: the censorial power is in the people of the government and not in the government over the people. Well, of course, the Constitution was passed. The Bill of Rights was passed in 1791, and not just a few years later, the Alien and Sedition Acts came along, passed by the Adams administration to keep out basically dangerous French notions of liberty and punished critical speech and dissent. So it was a kind of a fallback to this former attitude, but perhaps because of the timing, or probably because the law hadn't been developed to that point, it was never judicially challenged as a violation of the First Amendment. So here's a fact that I continue to be astounded by, but it's a true fact. For the last part of the 18th century, the whole of the 19th century, and nearly the first quarter of the 20th century, the First Amendment lay dormant in the courts. It's not that the right of free speech wasn't publicly recognized. It was, but it wasn't legally enforced in any sustained way. There were occasional cases that involved the First Amendment, but really, and I will also explain one very important reason why that was when I get to it. But as I said, these free speech rights were publicly recognized. Some of you may recall or have heard about and I think the documentary refers to it, the free speech fights of the industrial workers of the world, the Wobblies. That started right here in Missoula in 1909 and then spread to the West Coast and became a very potent weapon for the Wobblies. They were known as free speech fights, but candidly and honestly, although it was obviously a free speech demonstration, it was really more about publicity and organization and recruitment for the Wobblies than it was about demonstrating for free speech. Nonetheless, another indicator that we have of the way in which free speech attitudes were seen in 100 years ago would be to look at the role of the press, or what did the press have to say about free speech and the First Amendment protection for the press as well. Well, the press didn't seem to recognize the value of the First Amendment. In fact, if we look at some of the pronouncements in the newspapers at about the time that the sedition law in Montana was passed, and let me just read you a couple of these. This is from the Anaconda Standard, which was, although it was called the Anaconda Standard, it really served Butte, which was the largest city in Montana, and also served a somewhat more progressive community than other parts of the state, but nonetheless said, an individual who thinks that because he lives in free America, he has the right to say what he pleases about the country, government, man in uniform or flag is in for a rude awakening. When it comes to a question between liberty and patriotism, then let liberty go by the board. And the Daily Missoulian, as it was known then, editorialized, we limit speech today that it may live free forever. I mean, how 1984 is that? Whenever a free and self-governing people fights for more freedom, it must momentarily restrict its own liberties. But liberties so self-repressed are never lost. They are only laid aside where they can easily be reached. I mean, very laughable notions, I would say, about the role of free speech. And what they were referring to, and I just to basically put this in context, the Montana sedition law, which was passed on February 23rd, 1918. I'm not going to read you the whole lawyerly long sentence, which goes on for a whole paragraph, but basically it says, I'll read you parts of it. Whoever shall utter, print, or write any disloyal, profane, violent, scurrilous, contemptuous, slurring, or abusive language about the form of government, the Constitution, the flag, the soldiers, the uniform, et cetera, shall be guilty of sedition. Well, those are very broad and really undefined terms that were easily taken by juries with the help of judges to easily convict those people who were convicted, and the 79 people who were convicted, and 41 of whom were sent to prison. So when the U.S. Supreme Court first addressed the constitutionality of sedition laws after World War I, the majority used what was then the traditional standard and had been the traditional standard for a long time for judging so-called seditious speech, whether it had a tendency, even a remote tendency, to stir people to resistance or rebellion against the government. So this is called the remote tendency test. And look at it this way. This is a kind of an analogy that I developed for my students when I was teaching media law. Imagine that the federal government passes a law saying that after there has been a terrorist incident, because a lot of laws get passed after these kinds of incidents, the law says whoever shall be in possession of an instrumentality of terror, shall be guilty of this crime. And included in the definitions of an instrumentality of terror is a pair of scissors. Okay, because scissors could be an instrumentality of terror, could they not? Okay, so very remotely, one could get a pair of sharp scissors through security of an airport. Excuse me if I left out the part. The law also says within a 5-mile radius of any federally funded airport or something like that. Okay, so under the bad tendency or the remote tendency test, if somebody were found in possession of a pair of sharp scissors within 5 miles of an airport, they could technically be guilty of this law. That's how the bad tendency test operated. Okay, it swept huge numbers, or had the potential for sweeping huge numbers of people into its net. So with the World War I cases, Justices Oliver Wendell Holmes and Louis Brandeis began to develop a more expansive notion that would give more breathing room to political dissent. But it's also important to note that they never prevailed in a single sedition case that came before the U.S. Supreme Court. I just want to read a little bit of one of the most famous passages from opinion written by Justice Brandeis called Whitney versus California in 1927, in which he kind of lays out this broader view, this more tolerant view of dissent in wartime or not in wartime. And he says, those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government that deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness, et cetera, sort of holding up these idealistic people. And then he goes on to say, fear of serious injury cannot alone justify suppression of speech and assembly. Men feared witches and burnt women. Just let that sentence sink in. It is the function of speech to free men from the bondage of irrational fears. To justify suppression of speech, there must be reasonable grounds to fear that serious evil will result if free speech is practiced. There must be reasonable ground to believe that the danger apprehended is imminent, and so on. So he's laying out a much broader, a much more, a standard that encompasses a great deal more free speech. But as I said, even in that case, that was in essence a dissenting opinion. But it was actually another much less well-known case called Gitlow versus United States in 1925, a couple of years earlier, that was the one that radically expanded the First Amendment. The words "Congress shall make no law" that in the beginning of the First Amendment, and then leaving out the religion clauses, Congress shall make no law abridging the freedom of speech, had until then been taken to mean only federal action, only things that the federal government did. But in 1925, the court, almost in an aside, said, we assume that the 14th Amendment, which had subsequently been passed after the Civil War, the 14th Amendment protection of due process means that every citizen is covered, and therefore the First Amendment applies to state law as well. So it took the First Amendment from this very narrow focus on just the federal law and actions by the federal government to this much, much more expansive domain of state law, municipal law, any kind of governmental law in the United States was then subject to the First Amendment. So you have kind of the stirring words of Justice Brandeis in 1927, preceded in 1925 by this enormous expansion of the First Amendment in this case called Gitlow, and that really was the foundation for the modern First Amendment, which was built upon by the Supreme Court in subsequent cases. Just to mention a couple, in 1964 in New York Times versus Sullivan, a majority of the Supreme Court agreed that punishment for criticizing official conduct was contrary to the First Amendment. In that case, the court recognized that Southern politicians were so easily able under state libel laws to obtain crippling judgments against newspapers, in this case the New York Times, for essentially calling them out as racists, that the Supreme Court recognized that this was punishment for critical political speech. So that took a giant step toward basically burying the notion of the viability of sedition as a crime in the United States, although it was framed in the context of libel. Okay, and then it also set up a new standard, basically making it a great deal more difficult for public officials and public figures to sue, which is the law of the land today, and it's no wonder that President Trump would like to change that. And then finally in 1969, which again astoundingly is only 48 years ago, in a case called Brandenburg, involving the leader of a Ku Klux Klan rally in Ohio, the court set the current standard for punishing forceful political speech. A person cannot be criminally punished for urging the use of force or for urging that laws be broken. And here's the standard: except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite such actions. In other words, mere words, unless they're intended to immediately provoke lawless action and are likely to do so, cannot be punished by the state. So that sort of put the final nail in the coffin of sedition as a crime in the United States. And of course, had that law been in effect in 1918, no sedition law possibly would have been enacted. And for those of you who have been reading up on Trumpland, this is the standard of a current lawsuit by protesters who were injured in a Trump rally in Louisville, Kentucky, a year ago. At the rally, Trump repeatedly said, "Get him out of here," before protesters were shoved and punched by his supporters. Trump's attorneys sought to have the case dismissed on free speech grounds, arguing that he didn't intend for his supporters to use force. But a U.S. District Federal Judge noted that speech inciting violence is not protected by the First Amendment, and ruled that there's plenty of evidence, not only in that one rally, but in preceding rallies, that the protesters' injuries were a direct and proximate result of Trump's words. What that means is that the case can continue to trial, and is another example or perhaps is another example of the president tripping over his own words. And then finally, I would like to mention the Pentagon Papers case in 1971, which sided with newspapers printing of top secret Pentagon documents about the about the Vietnam War, with the exception being when a publication will surely result in direct, immediate, and irreparable harm to our nation. So there's a bit of a there's a bit of a loophole there, but pretty much says that the government can't step in and restrain the publication of material unless they can prove that standard. And except in one federal case, which I won't go into, in the 70s, the government has never shown that, proven that standard. So that really, I would say, was kind of the high watermark for the press in terms of constitutional protections. And now, are we nearing the other end of the sine wave of liberty versus security? Well, the short answer is we're not there yet, but we're getting closer. So shifting from constitutional law to the role of the news media in forming political discussion in this country, the same 45 years have brought enormous changes in communications and news media, as we all know. What was the, I guess I'm maybe talking to the younger people in this audience, what was the world of newspapers like in 1972? Well, I can tell you because I was a cub reporter then, or had been a cub reporter just in the years previous to that. Well, as a reporter, as today, you know, I took my notes in a notebook, or I typed them onto a typewriter. I typed it in triplicate, and I spiked one copy on my desk. There was a large spike on my desk, and duplicate copies of stories went onto this very dangerous spike, and then another copy went to copy editors who sat at a U-shaped table and copy edited to death, and then the copy went to another room to a typesetter who set it in type, and then that type was molded into things that were called stereotypes, and then onto plates, and finally wrapped onto huge presses. And there was home delivery. Well, I guess there's still home delivery, but in that time, you know, almost everybody got their newspaper through home delivery. Journalists had, you know, lifetime jobs, pretty much, if they wanted. There was competition by other newspapers in most markets. Newspapers had huge advertising sections, and I would say that there was a general trust in serious news media. So looking at, you know, the world of media in 2017, if you just look at it from the consumer side, you know, first of all, there's almost an infinite variety of sources on the internet. There's, including social media, and there's plenty of people who just get their news through links on social media. So you now have the freedom to construct your own bubble rather than the serendipity of the newspaper page where, you know, adjacent headlines caught your attention even though you may not have wanted to go to those headlines. Cable news shoutfests, shortening and repetition of the news cycle. I could go on and on. So from the journalist side, you pretty much have to be a jack of all trades. You know how to do photography and videography, and you have to use social media, constant updates, so you have to be completely flexible in an environment in which there are low wages and no job security. So things have changed enormously. I would say quickly that the main agents of change have been, one, the internet and technology associated with the internet. And the main thing that has done is that it has totally eliminated barriers to entry. That is, anybody who wants to, quote, publish, can publish. And, you know, it can be unsourced, it can be opinion, it can be doggerel, it can be fake news, obviously. So there's no barrier to entry. And of course, the worldwide transmission of that is also extremely free and uncomplicated. Other factors, which I'm just going to quickly gloss over, the destruction of the business model of newspapers and the flight of advertising to the web, the rise of conglomerates and the devaluation of news, and finally the end of the fairness doctrine, the doctrine that used to require that broadcasters have varying and opposite opinions, that they broadcast those opinions. So what does that tell us about the balance of liberty and security, or what does that foretell? Well, I know this will sound a bit like a cop-out, but for one thing, I can say it's gotten a lot more complicated. We've certainly given up a lot of privacy, as one of the talking heads right at the end of the documentary said, because of the structure of the internet, email, social media, the ability of the government, business, and individuals to spy, monitor, and exploit information. That's been a huge change, one that is almost I would say almost impossible to comprehend how much of a change there has been in people's, first of all in the reduction in privacy, and second in people's notions about privacy or acceptance of invasions of privacy that go on daily, some benign and some not. So obviously it's increasingly harder to be, quote, off the grid, unquote. What about the ability to dissent in 2017, sort of the classic freedom of speech? Well, from the legal standpoint, I would say that you're probably in pretty good shape if you're a U.S. citizen. And what I'm inferring there, obviously, is that if you're a green card holder, or you're an immigrant, or you have no documented status, or you're a refugee, or whatever, you better be careful about what you say, because your status can be challenged. You can be, kicked out of the country. Perhaps not for just saying one thing, but it certainly puts you on the radar, and particularly in this climate. I would say that the danger to people who are not U.S. citizens, if I can just sort of divide the world into two, the danger to people who are not U.S. citizens in terms of freedom of speech is enhanced. Freedom of assembly, well, one of the cases in the golden age in the expansion of free speech rights was a case out of Oregon called DeJong, in which the majority wrote that the right to peaceably assemble is a right cognate to those of free speech and free press, and is equally fundamental. Okay, so that was a 1937 case, and of course that right, we have recognized that right ever since. But there have been some troubling recent developments in state legislatures in reaction to protests like Black Lives Matter, Standing Rock, post-election demonstrations, and it has come to the attention of United Nations human rights investigators, who recently issued a pretty scathing report about these state measures that jeopardize one of these constitutional pillars, the right of assembly. And the UN report says that they're highly concerned about these measures, some of which have been passed by legislatures, which criminalize protests, which criminalize protesters for protests that turn violent, for making protesters civilly liable for damages that occur, these kinds of things that would seem to be clearly unconstitutional. Of course, nobody ever said that a legislature couldn't pass an unconstitutional measure. They do it all the time. And these are and probably will be struck down. But it's alarming that so many of them have been passed in state legislatures in recent times. But you know what? We've been here before. Again, going back to 1918 Montana, the Montana Council of Defense, which is sort of the quasi-judicial, the quasi-legislative, quasi-executive, quasi-governmental agency during the time of World War I, to prevent as far as possible riots, affrays, and other forms of violence, it is ordered that no parade, procession, or other public demonstration, funerals excepted, be held without written permission of the governor. So that was in 1918, and judged by how people talked about free speech, these probably were accepted and yeah, they were accepted by people without much quarrel. Okay, so as far as freedom of the press is concerned, I think that there are two very troubling recent developments that I think are equally important. One is the Obama administration's war on leaks, which the Trump administration may well be continuing. Ramping up pressure on investigative reporting through electronic surveillance of sources, Espionage Act, prosecutions of sources of leaks of classified information, going after reporters directly to reveal their sources, such as the New York Times reporter James Risen, who wrote about a failed CIA effort to sabotage Iran's nuclear program, and then he was subpoenaed, and that case got as far as a federal appellate court upholding or ordering that he testify. That case hasn't gotten any further, but nonetheless, it's pretty troubling. Also subpoenaing telephone records of news organizations, including the Associated Press. There's a good summary of all of this, by the way, in a Committee to Protect Journalists website. It's a 2013 report. It's pretty lengthy, but a very good summary. The other development that I think is equally disturbing, and yes, you guessed it, Trump's attacks on the press. You know, Trump tweeted on February 17th, "The fake news media, failing New York Times, et cetera, is not my enemy. It is the enemy of the American people." Sick. So the press has recognized that some of the press weaknesses in the last year were self-inflicted. For example, columnist Leonard Pitts said, "Among our sins, the failure to take Trump seriously enough, early enough, relying too heavily on flawed polling, spending more time covering personality than policy, providing him untold hours of free advertising, false equivalence, behaved as if Hillary Clinton's shifting explanations for the use of a private email server were somehow as ominous and potentially consequential as Donald Trump's mendacity, crudeness, etc." So questioning the legitimacy of the news media has some resonance, but claiming that it is the enemy of the people not only has the scary authoritarian and even fascist overtones, it is patently and demonstrably false. It may also turn out that Trump, by painting the press as the enemy of the people, has actually helped revive real journalism. Yet, we have to face the fact that people like Alex Jones of InfoWars, who promoted the conspiracy theory, among others, that the Sandy Hook shootings in 2014 were a hoax, is to some people a source of news and a symbol of sticking one's thumb in the eye of the establishment. There's plenty of folks out there who have no use for the mainstream media and never have. And it turns out that there are strong motivations to promote and consume fake news. A social scientist named Kate Starbird at the University of Washington studied social networks in crisis situations and began noticing strange clusters of wild conspiracy talk after every incident of mass shootings. And when mapped she noted they pointed to an emerging alternative media ecosystem on the web of surprising power and reach. Just what is this alternative media system saying? To quote her, the true common denominator she found is anti-globalism. Quote, to be anti-globalist often included being anti-mainstream media, anti-immigration, anti-science, anti-US government, and anti-European Union. Worse, the mainstream media attempting to debunk these myths only seems to make it worse. If the media is trying to debunk it, then the conspiracy must be true. The information networks, says Starbird, that we have built are almost perfectly designed to exploit psychological vulnerabilities to rumor. And she concludes rather pessimistically that we may be headed toward the menace of unreality, which is that nobody believes anything anymore. More optimistically, Simon Jenkins of The Guardian says, quote, the old maxim held that a lie can be halfway around the world while the truth is still putting on its shoes. What is different is that those shoes are no longer needed. A political lie is no longer sanctified by office and received as wisdom from on high. It is just news sent racing around the globe and pursued by an instant cloud of reaction. And libel laws themselves may help rein in some of the excesses of fake news. You'll recall that another of the fake stories spread by Alex Jones was the Pizzagate conspiracy and involving a restaurant in Washington, D.C., and which hurt the business of this restaurant. And Jones, uncharacteristically, apologized. Well, you know, he wasn't exactly apologizing because he got out of the right side of bed. He was apologizing because he was staring down a $100 million lawsuit. So in this case, you know, it could be that libel laws could work to help rein in some of the false fake news. And you know, news outlets themselves have pushed back. As well by making statements and organizations that represent news outlets. And I think that the people who might have heard Washington Post journalist David Fahrenthold here on March 13th had to be encouraged by the current state of mainstream media. And David, I jotted down a few of the things he said that kind of go to his attitude. You know, he says it's not our job to be on the opposing team. We're not the enemy. But we do have to be more explicit in showing our work, how we're trying to get stories. In other words, be more transparent. And we have to avoid shrieking with outrage, which is unfortunately a common mode of the news media, especially cable news. So, in conclusion, for those of you who watched the film, we can recognize that Hermann Bausch, the German farmer in the documentary, was a brave man who refused to give in to the people who were pressing him to contribute to the war. And he was imprisoned by a state gripped by fear and hysteria. And we can recognize the warning of Governor Schweitzer at the very end of the documentary about Muslims being next, because that day has come. We can stand up for freedoms and constitutional liberties, and we can stand alongside those who are oppressed. All of this in a far more complicated world than 100 years ago. Searching for truth is still important. It's very important. It's a lot harder, but ultimately the fate of our nation depends on it. Thank you.
Thank you, Clem. Our next speaker is Jim Taylor. So Jim received a bachelor's degree in political science from Carroll College in 1977 and graduated with honors from School of Law in 1980. After 15 years of private practice emphasizing criminal defense, he worked for a decade as managing attorney for the Confederated Salish and Kootenai tribes and did clinical supervision at School of Law for several years also. In 2007, Jim accepted a position with the University of Montana's Marine and Mike Mansfield Center, which led to working in China for 2 years on criminal justice reform with a Swiss-based organization called International Bridges to Justice. In 2008, Jim was named as a Fulbright Senior Specialist, traveling to Hungary for his first Fulbright placement and to Vietnam for his second placement. In 2010, he returned to private practice in Missoula, taught at School of Law, and did international consulting in Afghanistan, Georgia, and Vietnam. Since 2013, Jim has served as the legal director of the ACLU of Montana, heading up litigation on civil rights issues such as the death penalty, voting rights, and marriage equality. He has lectured and written about U.S. policies on torture and detention without trial in the U.S., England, Ireland, Italy, and Hungary.
So I think it's very brave of you all to stay awake this late, because we are like right at my bedtime, and we are past my wife's bedtime. So hopefully this will work. I want to talk to you about the detention of U.S. citizens as enemy combatants. This is a topic I've talked about in several countries, and one of the unique things about speaking on this topic is that as soon as I started speaking on this topic, when I would come back to the country, I would mysteriously get pulled out of the general line and go into the line with all the Muslim people. And there would be a long delay, and my luggage would be searched, my wife's luggage would be searched, and then there would be no explanation for why that was, and then they'd say, oh, I'm sorry, we can't talk about it, thank you very much, and eventually I get to go. And that stopped happening after the Obama administration was brought in, and then this last week, my wife and I had the opportunity to go to Canada to see our son, and coming back through customs, because I knew it was all sorted out now, was no problem. Coming through customs, I showed him our passports, and he said, turn off the car, please. Put your hand on the wheel, both hands on the wheel, and then our car is surrounded. And I'm sure this was just an unusual coincidence that I'm working for the ACLU, and that started happening again under the new president's administration, but there we are. So we're going to talk about what's an enemy combatant, because it's kind of an unusual concept. It's really a good question. Typically when we talk about combatants, the law of armed conflict talks about lawful and unlawful combatants. It doesn't define anything as an enemy combatant. How you're characterized as a lawful combatant and unlawful combatant depends on what rights you have under the Geneva Conventions. Everyone's heard of the Geneva Conventions. It's also called the Laws of Armed Conflict, which was adopted after World War II. These are agreements to which we are a party. But there was a case after World War II called ex parte Quirin, which we'll talk about in just a second. And there's just a phrase in there, kind of a throwaway phrase the Supreme Court uses, and it talks about enemy combatants. But it's not a defined term. There was no extended discussion about it. The court didn't elaborate on it. It's just something that they said. But it got latched on by the Bush administration, and it became a real thing. So have we detained U.S. citizens during times of war? And the answer is obviously yes, we have. During the Civil War, President Lincoln suspended the writ of habeas corpus. He wouldn't let people go to court to challenge their detention if they'd been arrested by the military. And the courts later, after the war, a case called Ex parte Milligan, said the president doesn't have the authority to suspend the writ of habeas corpus. The Constitution only gives that authority to Congress, and only in certain times. And so this was all unlawful what the president did. But these cases only got to court post-war. And I think that's a concept that we'll return to many times, is that courts are willing to intervene in these kinds of cases, just not when it's really important. Down the road, they're way more interested in intervening. But in the middle of an armed conflict of any kind, they really are not very excited about the whole prospect. In World War II, there was a case called Ex parte Quirin, we just mentioned. And this is the case of the German saboteurs. There were 8 German saboteurs, 2 of whom were U.S. citizens, were trained in Berlin in sabotage, captured in the United States, were to go to trial before a military commission. And they had petitioned for habeas corpus, and the Supreme Court said, well, the fact that they're U.S. citizens doesn't mean we can't try them before these military commissions when they have been operating as a belligerent, working on behalf of our declared enemy. So they were tried and summarily executed. That was the case right after right during World War II. But another really important case that happened during World War II is about Fred Korematsu. Fred was a U.S. citizen, born of Japanese descent, born in Oakland, California. He applied for service in the Navy. He wanted to join the Navy in 1940, but he had some medical conditions that prohibited them from taking him in, so he couldn't join. But he was part of the group that were swept up by the president's, FDR's order at that time, detaining people of Japanese descent. Didn't matter that they were American citizens. Didn't matter that this action wasn't authorized by Congress. He just went out and detained thousands of them because he wanted to, because he was afraid what they might do because they were of Japanese descent. And the U.S. Supreme Court did take a look at that, and they said, that was fine. That was fine. He didn't have to have congressional authority. It's probably one of the more shameful cases of the U.S. Supreme Court, along with Dred Scott and a few others. But the Supreme Court did say the president has that authority during times of war. And so even though Korematsu had committed no wrongs at all, never been convicted of a crime, no claims that he had an allegiance to the Japanese government. So when was that case overruled by the Supreme Court? Anybody have any idea? Never. That's exactly right. It hasn't been overruled. It's still the law of the land. So the next important thing that happened in terms of the detention of U.S. citizens was the McCarran Act, which is called the Internal Security Act of 1950. This was during the Red Scare, McCarthyism. It required organizations and Communist Front organizations to register with the Attorney General. It established the Subversive Activities Control Board, and it allowed, this is the scariest part, allowed the Attorney General to do preventative detentions. And if you're wondering what a preventative detention is, here it is. It's when the Attorney General determines there is reasonable ground to believe that such person probably will engage in or probably will conspire with others to engage in acts of espionage or sabotage. I don't really know what kind of prescient powers the Attorney General was granted by the McCarran Act, but apparently they were extensive because they allowed him to go out and arrest people because he knew what they were thinking. There were a number of provisions of the McCarran Act that were struck down by the Supreme Court over a period of 20 years. But it wasn't until the Non-Detention Act was passed in 1971 that Congress finally said, you know, this whole Korematsu thing, the detention of U.S. citizens, this idea that the Attorney General can detain people for what they're thinking, we're going to do away with that. And we're going to say 18 U.S.C. 4001, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. So it says Congress has to step up, excuse me, step up and authorize someone's detention. Otherwise, the president just can't detain them. So that's the law as it was when 9/11 happened. And 9/11 is a real watershed in terms of civil rights and civil liberties. It changed our view on a lot of things, and not for the better. If you look at things like the Patriot Act and the draconian measures that were enacted by the Patriot Act, that was adopted and considered in just a few weeks' time. No one actually in the Congress read it. Those were laws the Justice Department had wanted to get passed for years, but never had the political clout to get it done. You can bet that today there are other laws just as bad or worse that are being drafted and people will have ready. And God help us if we have another terrorist attack, because those laws will be trotted out and we'll go through another period like we did after 9/11. After 9/11, Congress passed what's called the Authorization for Use of Military Force. And it basically tells the president, okay, go identify the bad guys who did this to us and go get them. You have our authority. In the old days, Congress used to declare war. It doesn't do that anymore. But they do sometimes do something sort of like declaring war. And the Authorization for Use of Military Force is one of those things. And when we look at the war paradigm, anytime war is involved in the same sentence with civil liberties, it's not going to end well for civil liberties. Congress, that's where we get things like military commissions. And what we're in now with the war on terror, this is not like a traditional war that has an enemy, a foreign country, a beginning and an end. When we are at war, when war is over, is strictly a political decision. And unless Congress says war is over, war is not over. So as long as this war on terror continues, the government is going to have additional authority to impose restrictions on civil liberties. So, and part of the reason is textual with the Constitution. Under Article 1 of the Constitution, Congress has enumerated war powers: declare war, issue letters of marque and reprisal, make rules concerning captures on land and water, raise armies, provide for the Navy, make rules for the government and regulation of land and naval forces, and provide for calling forth the militia. So those are things specifically the Constitution says Congress can do. And the President also has powers under war. It has powers enumerated under Article 2. He's the Commander-in-Chief of all our military forces. And he can make those decisions. And the Supreme Court in Article 3 has no enumerated war powers. So there's always been a deference by the court to get involved in these kinds of cases, because the Constitution says Congress can do things. It says the President can do things, but it doesn't give a specific role for the court in the law of war or in times of war. The next thing we need to talk about real briefly is a case that took place during the Korean conflict called Youngstown Sheet and Tube versus Sawyer. And this was an important case, and not for the holding in the case particularly, but for a concurring opinion by Justice Jackson. And this today is a case that you will hear about anytime someone talks about national security law. In that case, Justice Jackson said that there were really three different categories of national security issues. One is when the President acts with his own Article 2 authority and congressional Article 1 authority. And that, so if the President is doing something that is as Commander-in-Chief and it's pursuant to an act of Congress, he has tremendous authority. And they'll give a lot of deference to his decisions. Another one is where Congress hasn't acted, but the President still has his authority under Article 2 of the Constitution. They'll give him some deference. And then lastly, when the President acts contrary to the express will of Congress. So Congress has said do this, the President says I'm not going to, they're not going to give the President's action a lot of credence. We'll come back to Youngstown Sheet and Tube because it's referred to in important cases of a more recent vintage. So I just want to talk for a second about terrorism and how it's been used to shape our laws from the threat that it does or does not pose. Since in 2014, there were about 2.5 million deaths in the United States from flu, 55,227. You remember the great flu scare of 2014? We lose that many people every year. We have actually an epidemic of flu. They tell you to get your shots, and that's really the end of the discussion about flu. From suicide, we lose 42,773 people per year. We did it in 2014. Of those, 8,030 were veterans. Car accidents, we lost 32,675 U.S. citizens. From gun violence, 12,587. Worldwide, for a period not of 2014, but of the decade from 2004 to 2014, this is worldwide, U.S. citizens, 303 were killed in terrorist attacks. And yet, if you look at the amount of energy and laws that have been generated to address terrorism versus flu, versus gun violence, versus car accidents, it's really rather astonishing. So we're going to talk now about whether U.S. citizens have been detained at Guantanamo. Anybody know the answer to that? Yep, there has been at least one. Guantanamo Bay is a naval bay in Cuba. We had a lease with the government of Cuba in 1903. It's a coal refueling station for the Navy. We signed a lease with Cuba. It was modified by a treaty in 1934 that said U.S. can stay there as long as they maintain the base. Cuba has long since repudiated the lease and said, get out, and we won't leave. We send them a check every year. They tear it up and send it back, and yet we won't leave. But the importance of Cuba, among other things, the lease says the U.S. recognizes the continuance of the ultimate sovereignty of the Republic of Cuba over the leased areas, and that the U.S. would exercise complete jurisdiction within the Guantanamo Bay refueling station while they are there. So the reason we ended up putting all the detainees from the war in Afghanistan and other places in Guantanamo is the theory of the Bush administration at the time is they considered Guantanamo to be the legal equivalent of outer space. Those were their words. They said, well, Guantanamo, it really isn't controlled by the Cubans, so Cuban law doesn't control. But it really isn't exactly controlled by us because we recognize Cuban sovereignty, so U.S. laws shouldn't apply there. So let's just take all these people and put them there. We don't want them in the U.S. We don't want U.S. courts to be able to rule on these cases. That was their theory. Even though they'd been ordered to leave Cuba, they still were giving credence to Cuban sovereignty, and so that's why they wanted to argue that U.S. law shouldn't apply there. So there have been a couple of U.S. citizens detained as enemy combatants, Yasser Issam Hamdi and Jose Padilla. Hamdi, we'll just talk about real quickly. Hamdi was a U.S. citizen of kind of a unique variety. He didn't know he was a citizen. He was parents were Saudi nationals. He was born in the U.S., but he actually didn't know he was born in the U.S. He was captured in Afghanistan. He grew up in Saudi Arabia, was alleged to have been captured on the battlefield in Afghanistan, supposedly affiliated with the Taliban unit. They still didn't say exactly when that happened, but it was sometime in late 2001. They brought him to Guantanamo, but then when they found out he was a U.S. citizen, they were really concerned about keeping a U.S. citizen there. They were afraid this might turn the courts against them on their theory of designating Cuba as a legal equivalent of outer space. So they said, well, we're going to call you an enemy combatant because remember that phrase from Ex parte Cura, and they said enemy combatant in there. So we've decided what that means. And it means whatever we say it means. And they took him to Consolidated Naval Brig in Charleston, South Carolina, and we'll talk in a little bit about why they picked that location. There were a number of cases, and I won't talk about the first 3 cases. Hamdi went up from the federal district court. People kept filing petitions on his behalf. It kept going up to the Fourth Circuit. Fourth Circuit would deny them and send them back. But eventually he got to his 3rd case, and this was an important case. The federal judge there was not at all satisfied with the proof the government had brought forward that Hamdi was a bad guy. There was something called the Mobs Declaration. Mobs was an individual worked for the government. And he filled out this declaration, and it was none of it was of his own personal knowledge. It's like, well, I've heard that Clem Work has done some bad things, and I heard some of it down at Luke's Bar, and I heard some of it at Charlie B's, and I've heard of it other places around town, and so you should detain him. I don't know any of it to be true, but I think it is, but I've heard it. That's really what was in the Mobs declarations. The Fourth Circuit and the district judge didn't like it, and the Fourth Circuit said, no, that sounds like really good evidence, really good evidence. So we'll allow that. They said the petition acknowledges that Hamdi filed was that he was captured in a zone of combat. Well, that's kind of an unusual thing to take that acknowledgement on behalf of Hamdi because nobody had been allowed to talk to Hamdi. These are relatives that are trying to file a petition on his behalf, but they weren't allowed to speak with him. His lawyers weren't allowed to speak with him for not like a short period of time, but for almost 2 years. And finally, the Fourth Circuit said, well, we've read this Non-Detention Act that you're talking about, but we don't think it provides any relief because the authorization for use of military force, we think that acts as authorization. We think that's congressional authorization to detain U.S. citizens. There's a petition for rehearing filed, petitions affirmed. There's a couple of dissents in the case. It goes to the U.S. Supreme Court. Now, as the case is going up to the Supreme Court, the real issue was whether Hamdi could even file a writ of habeas corpus. If the government's detained him as an enemy combatant, did he even have the right to file a writ? Which is a pretty ridiculous question because the Constitution says you have the right to file a writ of habeas corpus unless it's suspended by the Congress, and then only in certain really limited aspects, and none of that had happened. And I'll talk for just a second about the writ. It predates the Magna Carta in 1215. It says in our Constitution, the privilege of the writ of habeas corpus shall not be suspended unless when in the case of rebellion or invasion, the public safety may require it. So even back in the Civil War, the U.S. Supreme Court said in Ex parte Milligan, Congress never suspended the writ. The president had no authority to do so. So it's only Congress that can do it, and only in these 2 particular cases. And the federal courts have had jurisdiction to hear these writs since we've been a country, since 1789, since the first Judiciary Act. So it goes up to the Supreme Court, and the Supreme Court says, well, yeah, you have a right. Now, it's a plurality opinion. It's not a majority, which means that a number of judges agreed about the result, but they agreed for different reasons. There's no majority opinion that says exactly what the law is, but a plurality of them all agreed on the result, and the result was Hamdi had a right to some kind of a hearing in federal court. He had a right to go into federal court and challenge his detention and have a federal court hear the matter and issue a ruling on whether it was reasonable to detain him or not, even in times of war. And they were especially adamant that he had the right to counsel, that they couldn't deny him that right. And I won't go through all this, but I just point this out. This is some language from the opinion, but I just pointed out to you because it goes back to the Youngstown sheet and tube case that we discussed. And they go through that analysis to see where this fits in to that. And it says there is a role for the courts in that analysis, that even though there's no enumerated war powers for the federal courts, their role is always to review the actions of the judiciary and the Congress. So what happened to Hamdi? Anybody know what happened to Hamdi? Now, this is a person who was so dangerous, he wasn't allowed to meet with his lawyer. He wasn't allowed to be in general population in a maximum security prison. What happened to him after this? They got this ruling. They let him go. Yep, they turned him loose. They held him for 3 years without any charges. They sent him back to Saudi Arabia on the condition he renounces U.S. citizenship. And he said, you know, I didn't know I was a citizen. And if that's what it means to you guys, I am happy to sign off. I will go home. Have a nice day. So what was the point of the case? The point of the case was the government was trying to establish that it could do this to anybody, including U.S. citizens. And that's a pattern that we'll see repeated. Another case I want to talk about, and this is a really important case, is Jose Padilla. Padilla was a U.S. citizen. He was arrested not on the battlefield or captured on the battlefield in Afghanistan. He was captured in the battlefield of Chicago. He was arrested on a material witness warrant. And a material witness warrant means you're not charged with a crime, but you're thought to know something about a crime, and it's thought that you won't participate in cooperating and giving information so they can arrest you until they can take your deposition. That's what he was originally arrested for. They thought he was involved in this dirty bomb plot. You know, a dirty bomb is a bomb that's not an atomic bomb, but it's got radioactive materials associated with it. So if it goes off, it doesn't necessarily cause a large explosion, but it irradiates an area. And the issue for his arrest had been issued out of the Southern District of New York, which is in the Second Circuit. He was transferred to New York. He was assigned a public defender, an attorney, a private attorney named Donna Newman, who we've met several times, a great person. And Donna went and met with Padilla several times in the jail and talked to him about his case and, you know, when his next appearance was going to be. And she came to talk to him one day and she said, well, where's my client? And they said, well, he's gone. Where did he go? Well, the military took him. She said, go on. Military, what do you mean they took him? They said, well, he's an enemy combatant. She said, well, what the hell is an enemy combatant? I mean, I don't know anything about that. Well, nobody did. It was, again, it's a concept, a legal concept that they really created out of thin air. And so she said, I'm going to file a habeas petition on his behalf and tell them they have to produce him and tell me what it is that's going on. He was my client. He was charged here in the federal court in the Southern District of New York. You took him from here. I want to know what's going on. And Padilla was certainly no saint and no angel. He had a history of criminal background. He'd been convicted of murder previously. He had extensive gang involvement. He was alleged to have traveled overseas and trained with Al-Qaeda. But when you're detained as an enemy combatant, back then, it meant you had no contact with anyone. Although he had been in the general population in the jail in New York, after he was taken out of there, he was allowed no contact with anyone, including his lawyers. Lawyers couldn't talk to him. For 21 months, they couldn't talk to him. And how was he held? This is the conditions that he was held in. Whenever he had to leave his cell, first he had to put his feet out, and he was shackled. When he was allowed to come out, he was surrounded by 3 armed guards in full riot gear. And then he was, they put earmuffs on him so he couldn't hear anything, and goggles, the blackout goggles, so he couldn't see anything. So where do you think what they were doing with this dangerous individual on this particular day. He was going to the dentist. So that's how we treated Padilla when we wanted to take him to the dentist. There's another Mobbs declaration in this case. Remember Mr. Mobbs from before, who had all the bad things to say about Clem? Well, he had more bad things to say about Mr. Padilla. And they were all based on hearsay again. So there was a number of legal challenges that were brought. The Second Circuit, however, they went back to Youngstown sheet and tube case and looking at how they should analyze the issue. They looked at the access to counsel issue. There was another declaration by somebody else who knew even less. This was a vice admiral in intelligence, and he said some rather remarkable things in Padilla's case. He said the reason he shouldn't have access to attorneys is we have to have robust interrogations on high-value detainees. They have to be robust, and it's important as part of the interrogation process that the Geneva protections for prisoners of war do not apply. We have to create this relationship of dependency and trust with them in order to facilitate the interrogation. And we're afraid that attorneys will act as accomplices to the accused, and it will interfere with our robust interrogation and our relationship of dependency and trust. And the standard the government, that the federal courts were looking to apply was just there has to be some evidence. But probably it can't be just the made up evidence. Probably it has to be somebody who actually knows something. It can't be somebody who heard somebody say something at Luke's bar. And there has to be some indicia of reliability. So it can't be, well, I think this is true, and I'm kind of sure it is. You need to have some kind of reliability for the evidence. But the Second Circuit said, you know, we've looked this over, and, you know, this whole authorization for use of military force, we don't think that satisfies the Non-Detention Act. The Non-Detention Act says it has to be an explicit act of Congress, and we don't think telling the president he can go get the bad guys really encompasses what you want to do here. So it goes up to the Supreme Court, and they granted cert on two questions. Does the authorization for use of military force satisfy the Non-Detention Act? And did the district court have jurisdiction? And this case was argued just an hour after Hamdi. There's a website called oyez.com. If you ever want to go back and listen to the arguments, if you're that much of a legal geek like I am, these were really fascinating arguments. Both Hamdi and Padilla were great arguments to listen to. On the issue of counsel, an hour before, or I'm sorry, just like a day before, Padilla's brief was due on denying him right to counsel, because that was one of the issues they wanted to present to the court. The government said, okay, you can talk to him. They did not want the U.S. Supreme Court to get involved in that issue. So it's significant that they could talk to him. It was completely monitored. You know, there were recording devices in the room. There was nothing confidential about him. He didn't know he had attorneys at that point. He'd been there for 21 months. But they said, well, we can revoke this access at any time. You can talk to him, but it's not really a right. And by doing that, the Supreme Court refused to hear arguments on that issue. They said, well, he's getting access to counsel, so we're not going to let you argue that he's being denied counsel. And again, you'll see that's a pattern the government repeats. And this is a little bit of an aside. We had a speaker. I was president of the Montana Association of Criminal Defense Lawyers, and we had a speaker come and talk to us, and he said, you know, I think there are other U.S. citizens being detained as enemy combatants. I thought, well, that's interesting. So I wrote to the Department of Defense, and I said, is that true? And of course, I got no response. But I actually knew Representative Rieberg fairly well, and he was pretty tight with the Bush administration. So I wrote to him and said, you know, I've heard this. I don't know if it's true or not. I'd like some confirmation. And he wrote to the Department of Defense, and he said he's a constituent of mine, and he's asked for this information, and you should just give it to him. Here's the response that I got back from them. And then there'll be a short public statement by Alberto Gonzalez. My response was given in 2003, and Gonzalez was 2004, a year later when he was White House counsel. Barry Sabin, who was the chief of the counterterrorism section of the criminal division, Department of Justice, says, Department of Justice is not actively involved in detaining enemy combatants. We are therefore unable to answer your specific inquiry. So that's what we got back in writing, and I have that letter someplace from the Department of Justice. And then less than a year later, Alberto Gonzalez makes this public statement. The Department of Justice has been involved in every case where there has been an enemy combatant designation was considered or imposed. We were involved in the initial review. The Attorney General reviewed it again. There's a separate review by the criminal division. The Attorney General advises the Secretary of Defense, and the Attorney General again reviews after interrogation concerning access to counsel. So that happened. And there's one other thing, and this is, again, it's a little bit of an aside, but I do think it's important in the context of these national security cases. Padilla's case went up and was argued to the U.S. Supreme Court, and there was one of the issues that came up during that case was could the government torture people? And there was a discussion between Justice Ginsburg and Paul Clement, who was the assistant solicitor at the time. So Ginsburg asked Clement, well, can we, if the law is what the executive says it is, does that mean we can torture people? And then Clement goes on and on and on, blah, 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 blah. You have to recognize the government is on a war footing, and you have to trust the executive. I mean, we couldn't take some belligerent like Hamdi, once he's been removed from the battlefield, poses no threat, and use that kind of force on him. And Ginsburg says, well, why not? The law is what you say it is. What's the constraint? And he said, well, there are treaty obligations, and you know, if you commit a war crime, you can be punished. And so I think there's lots of internal reasons. She said, well, suppose the executive says mild torture. Can we do that? It's not a soldier does something, but it's an executive command. Some systems do that. And Clement says, well, our executive doesn't. Our executive doesn't torture. Now, for those of you with gray hair like me, you probably remember when this argument took place and when the Abu Ghraib revelation came out. Abu Ghraib revelation came out within a couple of weeks after this argument. So one of two things happened. Either the government deliberately concealed what happened at Abu Ghraib from Clement, or Clement lied to the Supreme Court. I don't know which happened, but it's pretty clear that one of those two things happened. We don't use torture, and then just trust us. And then Barry Sabin again said, we're not involved in detaining enemy combatants. And Gonzalez says a year later, well, except for every step of the process, we are. Well, let me just skip through this, but we remember what happened with Abu Ghraib and what was revealed there. And the point of this is that the representation the governments make in national security matters aren't worth the paper they're written on. These really presage the development of alternative facts. They just say whatever they wanted and make anything like it was a real representation. So the Supreme Court ended up kicking the case out just on the issue of standing. They said, well, you should have filed it in the Fourth Circuit where he's being held, not in the Second Circuit where they took him from. And they said, okay, well, we'll start all over. We'll go to the Fourth Circuit. And so why did they want to do that? Well, the Fourth Circuit, as the lawyers in the room know, is probably the most conservative federal circuit court anywhere. They knew they were much more likely to get a decision that they would wanted out of the Fourth Circuit. The Second Circuit is not as liberal as the Ninth Circuit that we're in here, but it's pretty liberal. And so they didn't want decisions out of the Ninth Circuit. If you remember, the Second Circuit decision was that the authorization for military force was not sufficient grounds to detain somebody that would be a violation of the Non-Detention Act. So they eventually get the decision. I know I'm running low on time here. So they eventually get a decision out of the Fourth Circuit, and the Fourth Circuit says just exactly what the government wants. This person is too dangerous to be out in any kind of jail or prison. We have the authority to detain him for whatever period of time we think is necessary. And we're gonna just keep him here. And as soon as they got that decision, they said, and they decided exactly the opposite of the Second Circuit. They said the authorization for use of military force is all the authority you need from Congress. You can go ahead and detain them without violating the Non-Detention Act. So they got the decision they wanted from the Fourth Circuit. You know, they staged the whole thing to get the decision out of the Fourth Circuit, and they got what they wanted. And so what was the government's response? For this terribly dangerous person who they had to take out in hoods and blackout goggles and earmuffs and shackles to go to the dentist, what did they do once they got the decision that said he was, they could keep him, he was just too dangerous? They turned him loose. Well, they didn't turn him loose. They charged him with federal crimes on an unrelated matter entirely in Florida and released him from the brig. And the judge who wrote the decision was furious. He was furious with them. They said, well, just, you know, dismiss the case now. He said, I'm not going to do that. I am not dismissing this case. You're going to come in here and explain to me, you've been telling me for 3.5 years you had to have this decision. I give you the decision and you do this. And so the government finally appealed the case to the U.S. Supreme Court, and the U.S. Supreme Court just dismissed it and said, well, he's no longer facing detention in the brig, so it's moot. So the government will do whatever they need to do to get the venue that they want, to get the decision that they want. So we'll just jump through here, because I know she's going to wave another sign at me pretty quick, and I'm going to be in trouble. So we get to what Teresa wanted to talk about, was the National Defense Authorization Act of 2012. It's a bill that's passed every year. In 2012, there was a section in there that talked about detention of people. It was very controversial. There was a lot of debate about it. At the last minute, there was a compromise reached with Senator Feinstein, and this language was put in there that says, well, whatever this says in here, it doesn't change the effect of the existing law relating to the detention of U.S. citizens, lawful resident aliens, or any other persons captured or arrested in the United States. So whatever this says, it doesn't change anything. That's essentially what the NDAA of 2012 said. Well, there were a bunch of people that were concerned that wanted to know, am I going to be subject to detention? I don't trust what this law seems to say. I don't trust this one escape clause. It went up to the Second Circuit, again, a more liberal circuit. The Second Circuit said, we read this and it doesn't have any effect on U.S. citizens. This didn't change the law. Whatever the law was, whatever it was, it still is that. So the National Defense Reauthorization Act didn't change that. And so you can't bring a challenge to it. Case went up to the Supreme Court. Supreme Court refused to hear it. So that's kind of where we are today. We have a vacated decision by the Second Circuit saying that the authorization for use of military force does not give the government authority to detain U.S. citizens absent other explicit authorization by the Congress. We have a Fourth Circuit decision that says it does. And we have the NDAA that probably doesn't add anything to the discussion. Probably. And then in the recent hearing by Attorney General Sessions during his confirmation, he was asked about the detention of U.S. citizens. It's a really short discussion. He kind of hems and haws about it a little bit. He said, well, they would get a hearing under habeas. They'd get some kind of a hearing. Doesn't talk about what the standard is, doesn't talk about what the standard of proof would be, doesn't talk about how long they could be held. They don't ask him about the split between the Second and Fourth Circuits. They just kind of do their Congress thing and act like they're asking good questions and then confirm him. So that's where we are. But on a positive note, just in conclusion, things can change over time, not a short time, over a long time. If you look at a period of like 40 or 50 years, in 1988, Congress enacted the Civil Liberties Act, granting reparations to all the Japanese and their descendants who they imprisoned. It was signed into law by President Reagan. It acknowledged the inequities of what they had done. It actually was a straight-up apology for what they had done. It provided a public education fund to finance efforts to inform the public about the internment of individuals to prevent the recurrence of it. So those were all good things. And it discourages the occurrence of similar injustices in the future. Again, like Clem said, this is all cyclical. We have to go through this every few years. I didn't think I would be talking about this again in my lifetime. I really didn't. Right in the early years of the Bush administration, I thought when we were done with those discussions, Obama got elected, we were done with those discussions, but we were not by a long shot. But I will close. I know it's a red card. I can't play in the next game either. Fred, in 1998, though, Fred Korematsu was awarded the Presidential Medal of Freedom by President Clinton. There's now a Fred Korematsu Institute on civic engagement. They have the Fred Korematsu Day of Civil Liberties and the Constitution in California now, where he was detained. If you want to read a great amicus brief, you'd have to be another law geek. But if you are another law geek and you want to read a really inspirational amicus brief, which is a friend of the court brief, go to the U.S. Supreme Court case of Jose Padilla in 2004 and read the one that Fred Korematsu filed about why we need to stop doing these things. It really is inspiring. And the Fred Korematsu Institute, they even have a Facebook page. You can go there and like his page. Fred died in 2005, but in 2004, the year before he died, he made these remarks that I think are incredibly relevant now. No one should ever be locked away simply because they share the same race, ethnicity, or religion as a spy or terrorist. If that principle was not learned from the internment of Japanese Americans, then these are very dangerous times for our democracy. Those were Fred's words 13 years ago. And if you want to keep up to date on these issues, this is a great blog to read. It's called lawfareblog.com. It's probably got some of the best writing. It's fairly conservative, but some of the best writing on these issues going forward. So that's all I got. Thank you.
Thank you to both of you. So we're going to take just a couple minute break. If you want to stay with us, we're going to extend past our expected time of 8:30. Both of our panelists have agreed to answer questions beyond the 8:30. So we'll end it at 8:30 so that you can leave if you have a prearranged need to leave. But for right now, let's just take a couple minutes break. If you have your questions already written out, you can give it to our volunteer here in the corner. If you there and in the back there's Zach. And if you need a card, they still have them. So we'll meet back here in about 3 minutes. Let's try for 3 minutes, and we'll start with questions. Okay, so we're going to reconvene here and start with some questions. If everybody could take their seats, we're going to begin with some questions. I hope you've written it down. Okay, so the League of Women Voters have prepared some questions, and we gave them to Clem and Jim, and if at any time one of these questions that we already have presented to you jumps out and you want to answer it, I mean, you could even start with that, or I could start posing some questions.
Pose away.
Okay, you ready for me to pose?
Sure.
Okay. So the Montana Sedition Act, like the Espionage Act of 1917, they were categorized as emergency laws. So the Patriot Act and the NDAA were also brought on during a state of war. So the question is, what is the responsibility of Congress to exercise its war powers to examine the mission and effectiveness of the war on terror and, you know, of these tools that have been created? The second question on that is, what is the role of journalists who may be aware of the precarious, compromised state that we're in?
You want to tackle the first
And, you know, that's a question for both of you, so if you can just jump in if you have a response.
Well, I'll just tackle the second part. I mean, I think that the role of journalists is especially important in times of heightened national security issues or times of war, and that is that as Montana and other parts of the country demonstrated in World War I, there was basically rampant fear and hysteria, and cutting through that is a difficult but necessary task for the press.
In terms of Congress, unfortunately, I think in large part the answer is political rather than legal. There's no way to enforce the Congress to exercise its war powers and its oversight, except in the context of mistakes that they make. The U.S. Supreme Court in Hamdi made it clear that at some point there's got to be an end to this war on terror, this concept of the war on terror and using the war paradigm to analyze civil liberties issues. But what the outside parameter of that is, I have no idea. When the courts will be willing to pull the plug on Congress and say enough's enough, I don't know.
Okay. So here's another question for both of you, and it's very contemporary. Congress recently passed a law, and I believed it was signed by President Trump last night or the night before, allowing internet providers to sell customers browsing history and other information. So is this a big deal? Does it imperil people?
Not if you don't use the internet. I think it's a huge thing. I mean, I do think there'll be a lot of pushback on this. I think that there's a lot of genuinely conservative Republicans who are not in favor of wholesale sale of our privacy rights. And if you look at what we do online now, it really runs the gamut of human activity. I think the idea that Congress is going to override this regulation and allow internet providers and ISPs to gather and sell this data is pretty reprehensible, and I'm hoping there'll be enough of a pushback politically to stop it.
And does it, the traditional words used in the Constitution to be secure in our papers, is there a correlation between that and our digital age way that we record our ideas and our letters and our catalog orders, you know?
I mean, I don't, Clem may have a better idea, but I think that there's a good argument to be made that in the context of today, that is where we keep our papers. I mean, I have more data on my phone now than people used to have in their house. I have enormous amounts of information about myself, my work, my finances, emails, and yeah, everything you've ever bought on Amazon, everything you've ever searched on Google, that's the equivalent of what our papers were.
Okay.
It's,
I have noticed that there is a lot of public concern about this, but I do have to say that I think there's a certain amount of hypocrisy here too by people who have simply gotten used to the invasions, the daily invasions of privacy by both commercial firms, by providers, by internet providers, by, large corporations, banks, as well as the government. So I think, I don't know, looking at it kind of a little bit skeptically, I think that some of this outrage is maybe a little misplaced, because a lot of that information has already been sold and traded and bartered and bought.
Okay.
yeah, who knows what's in that iTunes terms and agreement? Who knows? I just agreed to like a 7-page terms of service thing today, and I didn't have time to read it. Who's got, and if you had time to read it, who's got time to analyze it? I mean, those are contracts of adhesion that they just throw at you, and then once you agree to them, then they can do whatever it is that they intended to do with that stuff.
Okay, so our league members have sorted through questions and made them legible for me. I have from one viewer, we have one question goes to Jim and one to Clem. So, Jim, what is the difference between an enemy combatant and a prisoner of war? POWs have some rights that enemy combatants don't.
That's correct. And if you remember our discussion earlier, the laws of armed conflict, the Geneva Conventions, talk about the rights of unlawful combatants and lawful combatants. The whole legal category of enemy combatants is a made-up thing. And so it's a category where the administration can say, you have the rights that I assign to you and no others. Because they're saying they made up this category so they don't have to comply with the Geneva Conventions.
Okay. And Clem, please talk about the right to free assembly when much of public life now takes place on private property, for example, shopping malls.
Well, there is a well-established line of Supreme Court cases involving basically right of assembly and free speech in shopping malls, and essentially the conclusion is that it's up to the states to sort of set the parameters, and practically speaking, there have been some I would say a lot of deference to corporations that run malls to basically set their own rules about what can be, what can be said, or what kind of demonstrations or assemblies there can be on public malls. So, that's been limited. Now, as malls fade away, how relevant will that law be? I don't know.
Okay.
Can I
Go ahead.
add one thing? One thing that we've seen at the ACLU, and this came up a year ago, is that there were a number of demonstrations that were taking place around western Montana, and what jurisdictions were trying to do were saying, well, you can have your demonstration, but you have to get a permit, which people were willing to apply for the permit, and you have to get an insurance policy of $1 million. Well, no one's going to issue these insurance policies, and they're saying, well, that's really not on us. You we require it. Public good requires that there be insurance. And those restrictions have been struck down by a number of courts, and all of the jurisdictions that have those or that raise those issues back down when we send them a demand letter. But I think you'll see that continue.
That same insurance requirement was part of the package of requirements that was imposed on the neo-Nazi demonstrators in Skokie, Illinois, quite a few years ago now, but a series of cases that resulted in the courts affirming the right of free assembly, even in the case of the Nazis. But the insurance requirement was viewed as punitive.
Okay, so we're going to continue questioning after we formally end this, for the sake of anybody needing to leave. As a part of that, skipping forward here, we have literature tables that you can pick up your own pocket copy of the Constitution. We are going to continue questions in a second. I'm going to just finish this form, though, and I hope you do stay. We want to thank the UC here and MCAT and our guest speakers, of course, and they're going to continue. That's pretty much all I need to say. There are videos for sale, and thank you for coming, and thank you for staying. And we go on to the next question. I want to follow up. We were talking about protesters or people gathering. Thank you for coming. So do independent reporters covering protests and rallies, such as at Standing Rock when there was protesting, and maybe still is, the Dakota Access Pipeline, when the protectors of clean waters were there, do they need proof of intention or some sort of special credential to get them the same access to events and protections against arrest as reporters representing major media outlets? Do you know?
Well, I don't. I could guess that the rules of engagement change with the particular situation and who is the gatekeeper in that circumstance, but it's all takes place within a very changed ecosystem of journalism, where people who write blogs or who, with maybe one other person or a news organization, can, in some way present their credentials. But it's even credentialing the process is changing over time.
Okay.
The other thing that comes into the equation is what the journalist does. For example, if there's a protest and they're there filming, that's one thing. If the protesters decide to enter someplace illegally to take some kind of action and the journalist comes along and continues to film, are they still protected, or are they committing a criminal trespass? And this is a shifting landscape.
Okay, sort of untested. Okay, thank you. Somebody wants to know, is the Espionage Act that was passed during World War I still in effect?
It sure is. And it has been used to prosecute people who were suspected of leaking information. There have been, under the Obama administration, I think 8 different prosecutions under the Espionage Act, which is about 8 more than there had been before.
Okay. Clem, someone is wondering, was there financial restitution by the state to the families for the wrongful incarceration of their loved ones? So we're talking about World War I.
In the case of the sedition prisoners, no, there was no financial restitution. But for the governor to shake the hand of a survivor and of a descendant and say, I'm sorry, even though there's no price tag, there's no financial remuneration. I think that still meant a lot.
So the same audience members wondering, why did it take 35 years after the Sedition Act was appealed for the state government to acknowledge that error?
Well, actually, it took way more than 35 years. I mean, it really took almost 90 years for the.
And so why do you think it took that long?
Well, because we brought it up. we that is, Jeff Renz of the law school and I started this pardon project after my book was published, and with the help of law and journalism students, we made a case that nobody had ever made before, that nobody thought could be made.
Okay. This kind of had been forgotten, yeah.
Right.
So, Jim, this is a question. What about the extra legal use of prosecution, law enforcement, and other aspects of the system to chill dissent in advance by intimidation? So, for example, Cohen, Telpro, the Earth First Busters, Leonard Peltier, etc.
I guess I'm not sure I understand the question.
Yeah, I'm not sure I do either. Okay, so maybe that'll become clear. So state used propaganda, Clem, this is for you. State used propaganda campaigns to bolster an attitude against, I'm going to skip back to the league. I'm having trouble reading some of those. So, so Jim, can you explain the reasons, I guess you did, why the ACLU interpreted the 2001 National Defense Authorization Act as unconstitutional, or that it would be if it didn't have that clause. But if citizens are uncomfortable with it still, is there something they can do in the realm of null and void? If they find that the 1021, Section 1021 is offensive to the citizens, can they do a null and void? I mean, I know other states are doing it.
I don't know what you mean.
Well, there are municipalities and states that are doing a null and void, saying that it's unconstitutional and that there's a provision in law or...
Well, they can. It won't mean anything, but they can do that.
They can do it. Okay,
It doesn't. The supremacy clause of the Constitution says in these matters, the Constitution is the supreme law of the land. So whatever it says or doesn't say, unless it's unconstitutional, it is the law.
Okay.
And so the remedy is primarily political with the Congress.
Okay. So here's another amendment question. When the Fifth Amendment states, no person shall be deprived of liberty without, there's things in between, but without due process, does that mean that all people residing in or visiting the U.S., or does it also mean citizens and lawful permanent residents?
Is person limited to citizens?
Right.
I don't think they are, but the amount of process that you're due may depend on whether you're a lawful resident or citizen or not. What processes you will go through will be different.
Okay.
I think in general, one can say that the less contact one has had with the soil of the United States, or, well, with actual entry into the U.S., the less of that, the less due process, the less process may be due.
Okay, there's a gradation. So, Jim, could you speak to the 2014 Supreme Court case that was, actually it was declined, the review of Hedges versus Obama in regards to the NDAA, the indefinite detention provision of the 2000 NDAA? Yeah,
I think I did. The Hedges, the decision of the Second Circuit in Hedges is that the NDAA did not change the law on detention of U.S. citizens in any way, and So whatever it was before, whether it's the Second Circuit view or the Fourth Circuit view, that's what it still is now.
Okay, so Hedges is what you were talking about,
Right.
the second court.
Right.
Okay, Chris Hedges, the journalist. Okay. Okay, we just have a couple more here. Clem, from your research from Darkest Before Dawn, your book, what was your biggest insight about the human condition 100 years ago that can still inform us today about these times and ourselves?
Well, I think just remember Herman Bosch in the documentary. It takes a lot of courage to resist fear and hysteria, and that's a object lesson that I think we can learn from today.
So, thank you. Where are we most likely to find accurate and unbiased daily news produced by professionals committed to ethical journalism?
Well, other than
Facebook.
the standard mainstream media that everybody's aware of, I think, let me just point out a couple of go-to sites that I like to go to that are mainstream but maybe less well known. One is McClatchy, which is a small chain and notably famous for resisting the weapons of mass destruction line of thought that some of the other mainstream media adopted in prior to the Iraq War. And also there is an organization called ProPublica, which is a consortium, or basically an organization funded by news organizations that does deep investigative reporting. And I think it's a very reliable and trustworthy source. So those are just two.
Okay.
Isn't that the one that Sean Spicer just
Yes.
took a run at? Yeah.
Yes.
Okay. Okay, well, thank you very much.